Hi everyone. I'm going to talk to you today about 5 common mistakes that boards of directors make in the condominium world. I know I'm limiting it to 5. It's actually not that many. Often we see the same mistakes over and over again, but just here to give some friendly reminders on how to address those common mistakes. The first one is all too common: letting emotions make decisions. So these can be both positive or negative emotions, and they particularly come into play when we're addressing enforcement matters in a condo. So for example, Section 17.3 of the Condo Act places a positive obligation on condos through their boards to take all reasonable steps to ensure that the owners comply with the Act, the declaration, the bylaws, and the rules. However, what are those reasonable steps? This can become a complicated issue, particularly where emotions can be highly charged. Now, every condo has that one person who the condo has to repeatedly enforce its rules against in the past, or maybe even continuing into the present. You know, the same person parking in visitor parking all the time, the same person leaving garbage out in the hallway, or the same person with a pet that causes issues every other week. You've been inundated with complaints from other unit owners, and it's only human that you could become frustrated or angry with such situations. But it's important to keep those in check and maintain a professional level as a board member. Often anger or frustration can come out in things like overzealousness or perhaps taking too aggressive a stance in enforcement matters. Now, condos, through its boards, have an obligation to act even-handedly, take reasonable steps, and to treat all owners equally. This can be particularly difficult if you're coming at it from a place of frustration and anger. So if we can check those emotions when making our board decisions, maybe take a step back, take a deep breath, we can get past those negative emotions, and in order to see, well, what is in the best interest of the condo community and what are our obligations as a board under the Condo Act. Acting on those negative emotions can lead to potential consequences. Often if we're taking too aggressive a stance, a judge or the condominium authority tribunal can find the steps we've taken in such regard unreasonable. They can also find that too rash of a decisions can lead to potential cost consequences. The opposite is also true. Positive emotions can also get in the way of effective board decisions. You can imagine a situation in which you're on the board of directors, or another colleague is a member of the board of directors at your condo, and you're great friends with a couple of the other owners. And because you're great friends with those owners, you get along, you may look the other way at certain rule violations they may make from time to time. Perhaps your friend is parking in visitor parking spot and you think, oh, it's okay, Susie only does it every once in a while. Or Jim has a dog that's larger than what our declaration allows, but Jim is an easygoing guy and he doesn't cause any other problems. We're going to let this slide. That positive emotion of friendship and camaraderie can also get a board into trouble because, again, there's that obligation to treat all owners equally and with an even hand. You can't let the rules slide for one and not the other. Same, you can't bring down the hammer of the rules on one owner and not another. We have to treat everybody equally in that sense. So for that mistake, the common mistake is letting the emotions get into the effective governance of the condo corporation. I always say take a deep breath, bring it up at a board meeting, discuss it amongst everyone, and then go from there. Clearer heads always prevail. Common mistake number 2, I would say, is making decisions without quorum of the board. Now, Section 32 of the Condo Act provides that decisions of a condo board can only be made at a properly constituted owners meeting where quorum is in attendance and a majority makes that decision. This seems pretty straightforward. You have to have a board meeting and you have to have quorum at that board meeting to make a decision. However, this can take the form of any number of different kinds of decision-making processes, and some of them can lead to errors under the Condominium Act or mistakes that could have potential consequences. So there's often a situation where there's one particularly overzealous director. He or she goes around the condo on a daily basis, takes it upon themselves to fix things that the condo would otherwise be required to fix, or enforcing the rules on their own accord. Always that one director on occasion that's, I'm on the board, I have the authority of the board, I'm going to make the decision here. You're parking in visitors, or that dog is too big, or that music is too loud, and taking unilateral action. That director is making decisions and utilizing the authority of the board when a decision of the board hasn't been made by quorum. That can lead into some complications when trying to enforce later, and it brings up the issue of compliance with the Condo Act. Another form that not making decisions without quorum can take is not having regular condo board meetings. Most of the meetings are taking place over email, decisions are never ratified in the minutes, and it's sort of a laissez-faire governance of the condo. Now, you may have a full board and you may have decisions being made, but we're not in full compliance with the Act unless we're having a meeting to ratify those decisions and to conduct the business of the condo at a properly constituted board meeting with quorum. We want to see, particularly the Condominium Authority Tribunal wants to see clear minutes that are accurate and adequate, outlining when the board met, what the board discussed, and what the board decided. Another form that this can take is delegating authority to an officer of the corporation or to a contractor without board oversight. Ultimately, the board remains responsible for all the decisions made by the condo, quorum of that board. So you should have a regularly scheduled board meeting where you can review these decisions and that delegated authority to make sure those decisions are ratified and noted in your meeting minutes. The last form that I think this can take, and this can take a number of forms, but I'm just trying to hammer in on some of the common issues we see in the condo industry in this regard. Not passing board decisions by resolution. Now, resolutions don't have to be some fancy piece of paper that says resolution at the top. They can be marking decisions in your condominium's board's meeting minutes. What we want to see, and what the CAT wants to see, is a clear progression of discussion. So the board met, the board discussed the options available in making a decision, the board passed that decision by a quorum of the board. If we follow those steps, hold your meetings, record your decisions, vote on those decisions with quorum of the board present, then we should be safe and sound with respect to that requirement. Common mistake number 3. This one may sound a little bit self-serving, but I promise you it's not. And that is not listening to your lawyer or seeking legal help too late in the process. This is sort of in line with the old saying, you can be penny wise and pound foolish. Often we can save a lot of costs and prevent a lot of disputes if we can focus in on the issues and the potential disputes before they arise. One of the issues that comes about this is often with handshake deals or handshake contracts or verbal contracts, or hiring a unit owner in the condo to undertake the duties of the condo or to act as a contractor. These kind of things can have consequences that may not be anticipated, such as insurance issues or conflict issues or employment law issues. Seeking advice before we enter into those kind of contracts or agreements can save a lot of headaches in the future, and therefore a lot of costs in the future. Also, reviewing contracts with your legal counsel before you enter into them, particularly large contracts with multi-year commitments, is a very important due diligence process that we often do not see happen. You could enter into a snowplow removal contract for 5 years at a good price, and it sounds great. But 2 years into that agreement, if you're not happy with that service and you want to terminate that contract, if we look to the agreement, there may not be a termination provision, or there may be a large liquidated damages provision. These can cost condos a lot of money trying to get out later. We want to be able to look at these agreements before we enter into them and make sure we know the risks and limits and consequences before we make those large financial considerations. Another example of this happening is seeking legal advice perhaps too late sometimes. So for example, a condo could come to us and say, we would like to, borrow money out of the reserve fund to pay our ongoing maintenance costs, or we want to add a new sauna. Many of the owners want a sauna added to the condo, and can we do that? Well, we can look, of course, we have our Section 97 of the Condo Act. Basically, we do a cost analysis against the cost of the change with the amount in your budget. And based on that, it could provide that owners may need to vote on that matter before we can proceed. If we're provided with that question, and we provide our answer, but the issue is, oh, well, we've already done it. Now we're going to be spending more time and more funds limiting the liability for that and correcting the situation. So we can be penny wise and pound wise if we can address these issues before they become issues. I often see this in looking through budgets of condo corporations. Many condos budget nothing or $0 for legal fees, or a nominal amount of $100 to $500 for legal fees, when in reality, these things can cost much more money and become much more expensive down the line if we don't do our due diligence first and eliminate or seek to mitigate those complaints. So perhaps one of the mistakes is not budgeting for legal costs. If we budget now and we don't use it, great. We can roll that over into next year and compound that so you do have the money when it comes. But having a zero budget for legals or a nominal budget for legals can often lead to large special assessments later when an issue does arise. And of course, that leads to a lot of angry unit owners. Common mistake number 4, I would say, would be not listening to your other professionals or not seeking professional advice in certain things. Now, I'm talking about your engineer or your auditor, and particularly your property manager in this respect. Now, directors under the Condo Act have an obligation to act honestly and in good faith, and with the skill and diligence that a prudent person would in comparable circumstances. This is broad and overarching, but it's important to note that directors are saved from personal liability where they rely on the opinion of their property manager, their lawyer, their accountant, their engineer, or any other profession whose job lends credibility to the opinion they're making. What I'm saying here is let's not have an individual on the board making an assessment of windows in case they need replacement, or fixing plumbing issues in the condo on their own. What I'm talking about here is know the issues you have and engage the proper person to address those issues. Now, you don't always have to agree with the opinion of your professionals. You're certainly free to seek second opinions. So if you get, one plumber says this is a clog and this is what we need to fix it, and you think, well, that doesn't make sense to me. You have years of experience living in a condo building and you've seen this issue before. Get a second opinion, see what that plumber says, and then go from there. What we're looking to avoid here is making rash decisions without a basis for those decisions, and protecting the board's decision-making powers. And by protecting the board, we're also protecting all of unit owners. So if the board has engaged a professional to assist them with a particular task, and you rely on that professional, you've done your due diligence, and you've protected not just yourself as a director, but you've protected all owners in the sense that you now have done that due diligence and there's a basis for your decision. Finally, the 5th common mistake, and this is a common one, is charging back everything to a particular unit owner. Now, this is a hot ticket item in the condo world, and it has been since 2 cases came out a number of years ago. And you've all heard CCI talk about these before. That's the Inlani decision and the Rahman decision. Now, these decisions are still hotly debated amongst the industry, but generally, it's what those decisions stand for is that you may not be able to charge back enforcement costs or certain other costs without first obtaining a court order first. The Inlani decision, of course, dealt with the issue of smoking in a condo, and the Rahman decision dealt with parking disputes. And there were attempts in both of those cases to charge back all of the costs incurred. Now, this common mistake often goes with the first one that I mentioned, which was letting emotions guide board decisions. We need to take a step back and a deep breath sometimes and think what's in the best interest of the corporation when it comes to vigorously pursuing some chargebacks. Is this a matter which we need to go to court to decide? Is this a matter we need to go to the Condominium Authority Tribunal to decide before we can secure those costs? Now, that also goes hand in hand with the not budgeting for legal enforcement costs at the outset in your condo's budget. Very important to know that disputes will arise, and hopefully in 90% of cases we can resolve those disputes quickly and reasonably. But in the 10 to 1% chance we have to go further, that one problem can cause significant costs for your condo community. So it's important to get advice, be careful about the chargebacks, and treat all enforcement matters equally and reasonably.